I want to speak a little bit about the importance of this conference. Many of you certainly will be familiar, as we are at SALC, with the fate of the SADC Tribunal. In August, the SADC Summit of Heads of State and Government decided that a new protocol for the SADC Tribunal would be negotiated, and that any tribunal which emerged would only adjudicate disputes between member states, shutting down an incredibly important fora and space for the adjudication and determination of rights of individuals who previously have had access to the SADC Tribunal. And the fate of the SADC Tribunal obviously points very much to the vulnerability of institutions like the SADC Tribunal. The SADC Tribunal is not alone. We are increasingly, I mean, this conference today points to the importance and the number of supranational and regional judicial fora and legal bodies. These bodies which are so important in realizing justice and rule of law, but bodies which are very susceptible and vulnerable to political pressure. The US theorist and legal commentator Alexandra Bickel famously titled the judiciary the least dangerous branch. And I think at the supranational level, we might say that the judiciary, supranational regional judicial bodies, are not only the least dangerous branch, they are in fact often the most endangered, because they are so dependent on political consent and agreement. And their legitimacy is so dependent on cultivating an acceptance and recognition of the importance of the work that they do. And critical to conditioning that acceptance, that culture of legitimacy, is the dissemination of their work, so that the public might perceive the importance of that work, might perceive the avenues, the opportunities that are provided to them in realizing their rights. And the dissemination of their work is so critical, obviously, in meeting the requirements of accountability and transparency. For over 60 years now, since the conclusion of the Second World War, we have been said to be living in an age of rights. But that terminology is fallacious if the public is unaware of the rights they have and how they might be utilized. And that is why this project is so critical and so important to the recognition, to the realization of the rule of law here in Africa. And I want to, at the outset, thank and acknowledge AfricanLII for their vision in putting together this conference, in attempting to bring together supranational and regional bodies so that consent might be obtained and made meaningful in disseminating and access to legal information, the work that they produce, but to obtaining a real commitment to access to law, the law that they make and put into practice every day. I also want to thank the United Nations Development Program for having the vision to fund a project of this significance, which I believe will have real impact on realizing and making meaningful the rule of law in Africa. I want to thank all of you, who I know many of you have traveled very far to be here, and your willingness to do so, the fact that you're sitting around the table, is a reflection of your commitment to the project and your recognition of its significance. So thank you very much for being here. I wish you fruitful deliberations over the course of the next day, and I look forward to the outcomes of this conference. Thank you very much.
Ms. Ndroma of United Nations Development Programme sends her apologies. She had an urgent commitment she had to attend in Jordan. She sent her remarks, and this morning I'm standing in her place. I'll be Ms. Ndroma, affectionately known as Kukuvilagati from AfricanLII. Honorable Chief Justice of the Republic of Seychelles, United Nations Resident Representative in his absentia, Chief Executive Office of South African Litigation Center, our esteemed speakers and representatives, esteemed delegates from different parts of African region, AfricanLII coordinators, ladies and gentlemen, good morning. On behalf of UNDP, Regional Office for Eastern and Southern Africa, I welcome you to South Africa. I hope that you had comfortable flights and a comfortable stay in the hotel. As you know, Africa has taken remarkable strides in promoting the rule of law and enhancing access to justice and legal empowerment of citizens. However, despite international, continental, and national legal instruments which provide the normative basis for the rule of law and access to justice and the establishment of continental, regional, and national judicial institutions, a lot still has to be done to optimally dispense justice and legal security. As African countries seek to accelerate economic growth and the development of justice, legal empowerment and security of citizens has become even more important. However, the majority of the population is illiterate. Legal awareness is low. Laws are often not available or even simplified or translated for better understanding. Judgments are also not routinely written or published. This is compounded by poor law reporting, measures and limited availability and inaccessibility of legal materials, including primary legal information such as laws, judgments, court decisions, and secondary legal information such as legal articles and analysis. The general public whose knowledge of rights and responsibilities under the law remains low and have been adversely affected. Similarly affected are other stakeholders such as judicial officers and the legal profession, the academia, and students whose reliance on legal text for various purposes is key to their effective functionality. The largely manual court system in which court proceedings and judgments are handwritten and delays in publication of judgments often limits enforcement of decisions and creates uncertainty in society. It is within this context that rule of law, access to justice, and legal empowerment are at the center of the work of UNDP, where the focus is on strengthening justice-related policies, enacting laws, building legal and judicial institutional capacities, and empowering people. More recently, UNDP is embracing technology and ICT to increase knowledge of and access to law, of judicial decisions which are essential to a modern legal and judicial system and consequently constitute one of the basic tenets of the rule of law, an attribute of a transparent and functional judicial system. It is also an essential element of legal security that encourages investment, which in turn affects overall functioning of investment and trade that is encouraging for inclusive and sustainable development. As such, we welcome the establishment of AfricanLII and recognize the South African Litigation Center as a strategic partner who can assist jurisdictions across Africa to build and sustain internet-based law reporting portals. We are convinced that the expansion of AfricanLII is a significant opportunity to develop the capacities of African unions and the regional economic communities, organs, and institutions to harness and disseminate the legal information they generate, and to link them with National Legal Information Institute across the continent. We hope that through our financial and technical support to this meeting, UNDP will facilitate the exchange and sharing of how to make free access to jurisprudence and information across the region. We also look forward to the illustrated benefits from pilots in South Africa, Kenya, Malawi, Mozambique, Lesotho, Seychelles, and Swaziland, and to interest the AU and the RCC's institutions and organs of the African Court, the African Commission on Human Rights and People's Rights, the African Court, the SADC Tribunal, ECOWAS Court, and the EAC Court of Justice can be interested in similar initiatives and further be linked to the national lease. We are already aware that AfricanLII has brought about a broad shift in demystifying law and making legal material instantly accessible online to judges, to the academia, and publishers. Students are increasingly using the legal materials to study freely through online sources and use of cell phones. The public are reported to be reading the law more often, and there is increased commentary by the journalists on court judgments. We are keen for you to have a good understanding of how you can tap the potential of ICT and internet to strengthen your institutional legal information systems to produce and disseminate it freely to the benefit of Africans and beyond. Through UNDP's Regional Governance Program, we are committed to making the AfricanLII Catholic, to strengthening access to regional legal information, and to promote the respect for and effectiveness of the African legal and judicial system. Of course, there will be challenges. Judicial officers will need to reduce the time it takes them to write, present, and publish judgments. Leadership of your institutions will need to pay more attention on how to make your systems more functional by tackling information and case management processes. Policymakers within your institutions will also need to change their biased mindsets and attitudes towards ICT and to embrace digitization of legal information sustainably. UNDP stands ready to support such initiatives which require massive expenditure. We look forward to the outcome of this meeting and call for your commitment to strengthen your institutions through increased dissemination of legal information for their increased free access. I wish you a fruitful and a candidate discussion in this workshop. Thank you. We are welcomed by this note, and the session has begun, and on our first panel, we will welcome the Honorable Chief Justice of the Republic of Seychelles, Egonda Ndende. The Honorable Chief Justice Egonda Ndende is a Ugandan judge. He is the Chief Justice of the Republic of Seychelles. He was sworn into his new post on Friday, August 21, in 2009 at State House in Seychelles' capital city, Victoria. Prior to that, he served as acting justice of the Supreme Court of Uganda. He was also involved in the setting up of an independent judiciary in East Timor, where he also involved in the setting up of, where he served as a judge of the Court of Appeal. Mr. Egonda Ndende lectured law at Makerere University in Uganda and was chairperson of the Law Reporting Committee of the Judiciary in Uganda. He also has extensive experience in dealing with matters of drug trafficking while working as a judge in the United Nations mission in Kosovo. Thank you.
Dear colleagues, given the time available, I've decided that the best use of my time is simply the telling of the story of Seychelles Legal Information Institute, in the hope that it will illustrate the law and policy, or probably the lack thereof, with regard to access to legal information on the continent of Africa, the existing initiative in Seychelles, its impact so far, the roadmap for the future. But perhaps most importantly, it is to illustrate the work of AfricanLII and how much it can achieve with partnership with other organizations. In our case, it was a nationally, but it could as well be translated to a regional or continental level. And also the potential that this may have on creating access to the law on our continent. As it has been indicated by the gracious lady that introduced me, I went to the Seychelles in 2009. After swearing into office, I reported to my office for the first time in the afternoon of that day. As I was welcomed by the acting Chief Justice, who showed me to my chambers and gave a few introductory remarks. By my desk was a set of a 1991 edition of the Laws of Seychelles, which was incomplete. I picked one of the volumes, and my colleague remarked, "By the way, those are out of date. Do not rely on them." I then looked at the bookcase across at the wall. I saw Seychelles law reports. They stopped at 1987 or thereabouts. I wondered what I had walked into. How was I to find the law to apply in cases before me? I thought surely Seychelles is a SADC country, and perhaps Safili will at least have copies of the decisions of their courts. It was my next point of call once I was connected to the internet. Indeed, there were cases from the Supreme Court of Seychelles, but there were only 20. Not very helpful if the collection was that meager. The Supreme Court had 6 judges who sat alone. They must have produced more judgments than what I had seen. The Court of Appeal had 3 sessions a year and must surely produce more than 20 judgments a year. There was none posted on Safili. I must say that for some time, Safili and its predecessor website by the University of Wits, featuring the Constitutional Court of South Africa decisions, and the Kenya Law Reports, were the only websites that offered an online publication of the Superior Court's decisions in southern, central, and eastern part of Africa. Prior to my assumption of duty in Seychelles, I had collaborated with Safili, leading to the creation of Uganda Legal Information Institute. Uganda had only been marginally better than Seychelles at the time I started our collaboration. The problems were not very different. As I'd done in Uganda, so I did with Seychelles. I engaged in regional partnerships or cooperation. I shouted for help to the African Legal Information Institute, which was then just setting up shop after the reorganization of Safili. The African Legal Information Institute responded with great support. Kerry Anderson of AfricanLII and Thomas Bruce of Cornell Legal Information Institute visited and made on-ground assessments of the situation and some recommendations on the way forward. With the available electronic materials, AfricanLII built a website that provided initially a finding list of primary statutes and secondary legislation in force. At the time, kindly made available by a researcher with an interest in Seychelles law. Statutes and statutory instruments that were already available in electronic form, and decisions of the superior courts that were available, and others as they became available. We formally launched this website in Seychelles on the 7th March 2012, early this year. Free online access to Seychelles law was my answer to the question I asked myself on my first day. Where was I to find the law I was to apply? The vehicle for this to happen was the partnership and cooperation with the African Legal Information Institute and its principal funders, the South African Litigation Center. And even if the laws had been updated and available in hard copy, and the law reports of Seychelles had been available and up to date, the need for online availability of primary legal materials in Seychelles would still exist. The absence of updated availability of the primary law materials just made it more urgent to provide for free online access. Government policy. It is difficult to decipher what government policy is towards the digitalization of laws and providing online access, as officials of the same or different arms of government have different responses to the matter. Recently, while answering questions in the National Assembly, the Vice President indicated that the current law revision exercise is likely to be completed in August